Okay, good evening, everyone. I hope everyone is doing great wherever you are right now. And welcome to our fourth episode of the Strata Talk Show in this beautiful evening. My name is Amiza, and I will be your host for today's Strata Talk Show. So, this talk show is brought to you by the Excel Academy of Real Estate. So, our guest speaker for today is Mr. Patrick. And for today's episode, we are going to talk about party wall and interfloor leakages and introduction. So, guys, if you have any questions regarding this topic, feel free to write your questions in the Facebook comment box below. And hopefully, we can entertain your questions by the end of the session today. So, Mr. Patrick, how are you doing today?
Okay, well and good, well and good. Thank you,
All
Miss
right,
Amiza.
good. Good to know that. So, without further ado, let us welcome Mr. Patrick to start the session.
All right, thank you very much, Amiza. Right,
Okay.
good evening to all of you. And today's session is just a brief outline based partly on some of the feedback that we have received from participants during the webinar which we last organized. We had more than 200 participants at that webinar, and quite a number of persons have been asking. Of course, people are still asking about meetings, but I think we have dealt sufficiently with meetings. It'll become very repetitive if we were to continue with that any further. We have taken some of the more popular issues that have been raised by participants, and one of it is actually touching on the role and function of the management. How do we exactly know uh, what are the roles and functions of the management? And this is very interesting because uh, I've said in my previous webinar, many of you have attended, and even in physical seminars, that the stratified property goes through various management stages, initially being managed by the developer. Then at some point of time, the JMB comes in, uh, and or the management corporation comes in to the picture. So these are the three principal bodies which are managing. Whilst I did say these are the people who are managing, and I also mentioned about some of their statutory duties, their powers and duties. I did overlook maybe what exactly is the management role all about. And of course, during a short session like today, we can't hope to touch on all of them. But I want to touch on a key area that seems to disturb a lot of people who are living in stratified properties, and that is defects appearing either in their parcels or in the common areas. So the defects could appear in the parcel or the defects could appear in the common area. And sometimes the defects could arise as a result of um, connections between your parcel and the parcel beside you or the parcel above you. So we need to understand that when a person lives in a house, a landed property, usually they only have to deal with, if you are living in a terrace house, you deal with houses to your left and to your right. You do not deal with property which is above you. There are no properties above you. But if you're living in a stratified building, especially, you may not only have to deal with properties on your left and on your right, you will also have parcels which are above you. And so you can have two kinds of problem. One is interwall leakage, and this interwall leakage or damage could arise from your neighbors to your left or to your right. Alternatively, there could be what we call interfloor leakages. That is, your ceiling gets damaged. And these are kind of things that people ask, who do I claim against? What do I do about this? All right, now to answer this question, let's look at what the statute says or it is all about. Now, when let's take both of these defects generally first. The first question you need to ask is, when does this defect appear? This is a crucial question. Your defect may appear while you are still under the warranty period from the developer, or your defect may appear after the warranty has expired. Now, if you have the warranty period still alive and kicking, then you have certain remedies available, of course. One of these is the percentage of money which is supposed to be held by your lawyers and not to be released to the developer until after the warranty period has expired, or what we call the defect liability period. I just call it warranty in short. So there is a 5% retainer to be held by the lawyers, not to be released to the developer until after your defect liability period is over. So your claim is quite straightforward. You bring an action against the developer, and this is a short sort of guarantee. Now, your problem arises when your defect liability period is already over and that 5% which has been held by the lawyer has been released to the developer on the grounds that no complaints has been received, and you might get your damage appearing after the defect liability period is over. Then you may have to bring an action against the developer again, but in a different capacity, because the developer will be managing the place, and as the manager of the place you bring an action against the developer or against the JMB or against the MC. All right, that's one scenario. I hope you all get it. Now, the second aspect is not about when the damage arises, but more importantly is the source of the damage. What is the source of the damage? Is the source of the damage due to structural defects, design defects? Perhaps nowadays people want buildings with all kinds of designs, but certain things may not be so proper. If some of you may remember, some years ago, the MRR2 highway, especially the part leading near Kapong, was closed down because at that point they said that the beams which were holding up the highway, they have defective design, and if they were not shut down and something done about it, then it could cause serious damage. It could even lead to a collapse. So there could be a defect design, there could be materials which are defective in quality, and if there are materials which are defective in quality, there could be defective design, there could be poor workmanship by the developer. Then these are cases where you can bring an action against the developer based on your sale and purchase agreement. Okay, based on your sale and purchase agreement. Now, if you look at your sale and purchase agreement, your sale and purchase agreement will have a clause in the schedules which will say that the quality of the materials which are being used, they will mention about the quality. Now, if it is mentioned, then obviously you need to see how much you paid for your property. Did you buy for your property at 150,000 ringgit? Or did you pay what is mostly average price of about 400 to 500,000 ringgit? Did you pay a million ringgit? Did you pay 2 million ringgit for it? See, for example, in Glenmary Estate, there were supposed to be these superlink houses which were built. And these superlink houses, right, they had very high ceilings and very high roofs and a big area. But many people had complained for the reason that the quality of the materials used was very poor. I had a client who was arguing with the developer's engineer who came in, and this was what he said. He said, I am paying 12,000 ringgit a month installment to the bank. You expect me to believe that this is the kind of quality that you're going to give me for the price that I am paying? Now just imagine you're paying 12,000 ringgit a month installment. What kind of quality would you expect from a building of that price? So that's a very interesting thing. You look back at your sale and purchase agreements, there will definitely be a clause which will mention about the kind of quality and the kind of workmanship that is being applied. To take a simple example, sometimes your outer wall may have algae growing on it, the green color moss. And a simple explanation for the green color moss or the algae growing is that they did not use the external weather paint, the one which is resistant to algae, water resistant paint, but they used the ordinary paint just to save cost. It's a good example of poor workmanship, poor materials being used. So in this case, of course, you can bring an action back against the developer for what has happened. Now I'm focusing on the parcel itself. Then going on from there, you may have a situation where the damage is caused not by the quality of the materials or the workmanship of the materials, but the defect arises due to poor maintenance. And if it is due to poor maintenance, then you will have to track down on who is responsible for maintaining the place. And if it is the JMB which is supposed to maintain, for example, it might be sewerage pipes, it might be water pipes, it might be electrical points, it might be external paint work, then your action is against whoever is responsible for maintaining the place. So, number one, ask yourself, is it the defect has happened during your defect liability period? You bring an action against the developer. Number two, the defect arises due to poor design, poor workmanship, poor materials being used. And if that is the case, then your action is against the developer. It is a contractual action that you can bring against the developer. And three, if it is because of poor maintenance, then you must find who is maintaining the place, and whoever it's maintaining, whether it's a developer, the JMB, or the MC, then your action is brought against them. Number four, if the defect arises because of what your neighbors have done, your neighbors have done some renovation work, some drilling work, they have been changing their tiles perhaps, or they drop heavy things which causes damage, etc., then your action will of course lie against your neighbor. So these are the four possibilities whereby you can bring an action against the developer in different scenarios, against whoever is responsible for managing the place, and finally whoever is the cause of the damage, maybe your neighbor. All right, having said that, next we look at the possibility of damage happening to the common areas. Now we know that as a result of amendments to laws, every developer is supposed to have this fund, right? For common areas, if there are defects in the common areas, anybody, any owner, any parcel owner can apply to the Commissioner of Buildings, lodge a complaint with the Commissioner of Buildings, and state to the Commissioner of Buildings the common area is defective. And the Commissioner of Buildings will send their people to come and investigate. And if there is a defect in the common area, they will ask the developer to repair or make good the defect. And if the developer does not do so, they will utilize the money from this fund. And the COB is supposed to get their own people to go and make all the necessary repairs and charge it against that fund. So these basically is a very brief, simple outline of the way things can happen. Now, moving on from there, if your initial investigation shows that it is the developer who is supposed to be at fault, one of the common problems is most purchasers find it very difficult, challenging financially, time wise, to spend that amount of time. They also find it challenging to, in terms of stamina, to bring an action against a developer. Whenever a client approaches me and says they want to file a suit, one of my first questions after looking at the merits of the case is to ask them, do you actually have the stamina to run through the case? The case of a developer, the developer may have the means of outlasting you financially. They may put in all kinds of applications and cause you to stumble or drag the case along the way. So, do you have the stamina to last? Some people just say, no, I don't have it. Just leave it, forget about it. Now, if you have the stamina to do it, then you may want to take an action against the developer. However, it is wise always that if this problem is not unique to your parcel alone, but it is quite common to other parcels as well, or if it involves the common area, then a good thing to do will be to combine and bring a class action against the developer. Can the MC or the JMB bring an action against the developer on behalf of the owners? The answer is no. The answer is no. Unless the owners authorize the JMB to bring a class action on behalf. Now, even then, um, we could challenge it in court. If I was a developer's lawyer, and if the JMB or the MC has been authorized by the parcel owners, not necessarily all, but some of the parcel owners, to bring an action on their behalf, I would challenge the locus standi of the JMB or MC, because we must understand both these bodies are statutory bodies. I've said this very often. Their powers, their duties, their responsibilities are regulated by statute. And you will have to point out to the statute to show where they are authorized to act on behalf of the parcel owners to bring an action against the developer. So it might be a class action among all of you to bring an action against the developer in such a case. But please be aware that you must be able to point out it is the defect, the developers, maybe wrong planning, wrong design, poor workmanship, poor quality of materials used that cause these kind of things to happen. So it may not be your neighbor upstairs who is causing the interfloor leakage. It could be poor design, poor materials, poor workmanship. Maybe no waterproofing is done. Maybe the pipes and the conduits are poor quality and they have given way. This is something to be taken into consideration. Now, if you want to bring an action against a developer, there are three areas to look into. One is, what is the developer contractually bound to deliver to you as a purchaser? This will depend on the sale and purchase agreement and the deed of mutual covenants. So this is a contractual responsibility of the developer, and you'll find your defect liability period also stated in your S&P. Number two, the developer is bound by statute. And if yours is a housing unit, you will have standard sale and purchase agreements which are governed by the housing developers' rules and regulations. So the developer also has certain statutory duties and responsibilities which he needs to comply with. Three, the JMB or the MC, which takes over from the developer, they may incur extra expenses carrying out repairs or rectifying defects which arose as a result of poor workmanship, poor quality, poor design of the developer. In such a case, the JMB and or the MC can bring an action directly against the developer under the law of torts. Let's say the common area and the facilities are not complete, and as a result, the JMB or MC, which is responsible for the common area, has to complete the job. Then they can make a direct claim against the developer. Or if some of the facilities are of poor quality, defective, the JMB or the MC can bring an action directly against the developer because they are the ones taking over. The liability falls on them. They are given the responsibility to maintain the place. So, if extra expenses, extra burdens are imposed on them as a result of the failure of the developer, they can bring an action against the developer. Now, having said that, we have a case called Dua Residency Management Corporation against Edisi Utama Sendirian Berhad. Now, the case of Dua Residency Management Corporation and Edisi Utama Sendirian Berhad, the facts of the case very briefly are cracks and defects started appearing in the common area in 2010. After several failed attempts to get the developer to rectify this, the MC sued in 2019. Now, the MC put in their statement of claim, put forward three grounds. First of all, they said the MC claimed it was representing all the parcel owners. Remember, all parcel owners are automatically members of the MC if you have your strata title, of course. So they said, as representing the strata owners, they claim that the developer has failed in its contractual duty in ensuring that the common area is free of defects. Number two, they said the statute has put or imposed certain duties on the developer, and therefore there is a breach of statutory duty. Number three, they said that the MC now has a responsibility of rectifying the defects, and so they are incurring extra expenses. In the High Court, the High Court judge said that the MC cannot rely on the sale and purchase agreement or the deed of mutual covenants because the MC is not party to the contract. The contract is strictly between the developer and the purchasers. The MC is a foreigner to the contract. Therefore, it under the doctrine of privity of contract, it cannot enforce the terms of that contract, first and foremost. Number two, what about their statutory duty? Under the Uniform Building Bylaws 1984. Now, as far as this uh, Uniform Building Bylaws of 1984 are concerned, this regulates the workmanship and the quality of the work, the design that every developer has to comply with. Now, these Uniform Building Bylaws, however, if you're going under breach of statutory duty, it does not apply to the developer as such. It applies to the local council which approves the building. Please recall the Highland Towers case where the Ampang Jaya Municipal Council was held not liable because this is a public duty. Whether they owe the duty to the owners or not is a big question. These uniform building bylaws uh, are meant more for if you want to bring a judicial review application against the city council, town council, and all other approving bodies. The developer is not a public body, the developer is a private body, and as such, this breach of statutory duties does not apply to them. Number three, the court held that the MC could succeed on the grounds of negligence because, as a result of the negligence of the developer, cracks and defects appeared, and it fell on the MC to rectify the cracks and the defects. Therefore, the MC has incurred extra liability, extra expenses, and these extra liability and extra expenses can be set off against the developer. Now, it's a big, very interesting question. What if the developer has been wound up or is under liquidation? Then it's very unlikely that you may get any remedy against the developer. The MC may have to absorb the loss, and this in return will be reflected on the sinking fund accounts or the maintenance accounts because money will be used from there to remedy or to correct all the defects. If you have your statute book with you, be very interesting. I would like you to take note uh, of the regulations which have been passed to regulate these two key areas. And I want you to look at them. If you have a statute book, your Strata Management Act with you, and you can look at the strata management, maintenance and management regulations 2015. And if you were to look at regulation number 55, it talks about the meaning of interflow leakage. It says, for the purpose of this part, interflow leakage means any evidence of dampness, moisture, water penetration on the ceiling that forms part of the interior of a parcel, common property, etc., or any furnishing material, including plaster, panel, or gypsum board, laid or applied to the ceiling. So we are basically talking about two things. Interflow leakage covers damage caused by water, or there is dampness, moisture, or water penetration on the ceiling, or materials which form the ceiling. That is what interflow leakage is all about. Now, once that happens, the owner of the parcel is supposed to give a notice to the developer, the JMB, or the MC or there's a subsidiary management corporation, to the SMC. You have to give a notice in Form 28, and then they will come and inspect the place according to the Regulation 57. Within 7 days of receipt of this notice in Form 28, they are supposed to come and inspect the place. Right? Regulation 58 tells you about the various presumptions that apply. Okay. Once they have actually detected the cause of that leakage, then they will have to take the necessary action. Regulation 60 tells us that where the interfloor leakage occurs within a defect liability period, then the action is against the developer. But if it is due to defective workmanship or materials, then make in the common property, then you have to bring an action for under the common property defects account. Now, there are other things there, but you can read it on your own. Next is briefly to look at Regulation 65, which talks about what is a party wall. Okay, so party wall is a wall that separates one parcel from another or a parcel from a common property. Now, Regulation 66 talks about damage to a party wall. I want you to take note because damage to party wall is wider than interfloor leakage. Interfloor leakage is limited only to dampness and water penetration to the ceiling or materials which form part of the ceiling. But party wall damage in Regulation 66 talks about any evidence of dampness, moisture, water penetration, or other damage. Or other damage. It could be any other kind of damage as well. So note, interfloor leakage is dampness, moisture, water penetration. Party wall is dampness, moisture, water penetration, or any other damage. Right? So this is what we have to say about this topic today. So I will stop here for a while, and if you have any questions, I think and forward them to Chegamiza, and she will take it from there. Thank you very much. Thank you, Chegamiza.
Okay. Thank you. Okay, great. Thank you so much, Mr. Patrick. So I hope everyone gain input and understanding as much as I have. So now we are on into our Q&A session, and I can see there is some question coming from the participants tonight. So I will pick one of the question coming from TF Tan. Mr. Patrick, how if the parcel owner refuses to give access to the developer or JMB to carry out the defects inspection or rectification? Yes, into you.
Okay, thank you very much. Regulation 63 provides the person or body in sub 2. Let me go straight to sub 2. Any purchaser, parcel owner, proprietor, or occupier of the affected parcel or any other parcel who fails to give access to the affected parceler to the person or body carrying out the inspection commits an offense and shall on conviction be liable to a fine not exceeding 50,000 ringgit or to imprisonment for a term not exceeding 3 years or both. In fact, this is only if it is not an emergency. If it is an emergency, Article 63 sub 3 tells us forcible entry may be effected. Forcible. By force, they can enter into your premise under 63 sub 3. So it is a criminal offense. There's a fine. You can go to jail as well for failure to give access. I hope that answers the question.
All right. So, thank you, Mr. Patrick. Moving on to the next question, which is from one Farah. Sir, is there any specific format for the notice of the leakage to the developer or JMB?
Yes, this is a Borang Form 28. Form 28 is the form which will have to be submitted for this purpose. They can be found in the Act, it is there.
Okay. I hope that answer your question, one Farah. Okay. Moving on to the next one, to the next question, from Ko Chun Hao. Hello, Mr. Patrick. I would like to ask what are procedure for dealing with interfloor leakage in strata buildings?
All right.
Right.
Now, the first thing is, as a general rule, we must understand uh, the strata property laws that we have in Malaysia, Strata Titles Act and Strata Management Act, do not provide for an owner, a parcel owner, to sue another parcel owner directly. You mean, for example, you want to go to the Strata Tribunal, or you want to go to the COB, etc. You can't do that, right? Uh, if you want to go for direct action, you will have to bring a case of negligence or nuisance in the court. You have to sue in the court. However, having said that, the provision or the mechanisms that is provided is that the parcel owner who is affected by this interwall damage or interfloor leakage, or party wall damage or interfloor leakage, ought to lodge this Borang 28 with the whoever is responsible for managing the place. Whether it's a developer, whether it is a JMB or MC, you lodge your Form 28. And within 7 days of lodging that Form 28, as provided by the Act, the regulations here, right? The regulations provide that within 7 days from the date of receipt of the notice, they are to carry out an inspection. And in this matter, Regulation 58 tells us what are they supposed to do, because their job of inspecting is to determine the cause, the root cause of the damage. And once they have done it, once they've inspected, the next procedure is the JMB or the developer or the MC, whoever has carried out the inspection, they are supposed to prepare a certificate within 5 days after completing the inspection, right? That certificate will be in Form 28 as well. They will state there what is the cause of the damage and who is responsible for rectifying that damage. Now, then you take it from there. Now, if let us say, for example, I did one matter for my client in uh, one of the condos in Mont Kiara. He claimed that in his third room, whenever the rain hit, he was on the 37th floor. So, whenever the rain hit, the water seeped in and damaged the parquet flooring. Now, he himself was a developer, right? I mean, he's a director of a company here. It's a developer company. He himself is a developer. So he knows the rules. The MC has already been established. He lodged a complaint. He filed a form. Having filed the form there, the MC, what they did was they called the COB Kuala Lumpur. The COB Kuala Lumpur came and checked, or rather the MC first came and checked and said, no, this is your own leak. It's a leak which is coming from inside your parcel, so you will have to repair it yourself. He was unhappy. He lodged an appeal to the COB. The COB sent their people to inspect. They also concurred with the MC and said this is internal. Now, however, subsequent to that, he was still not happy, so he called me and I told him to bring his contractor. So the contractor snapped a photograph. I tell you, it was a very chilling experience for me, because on the 37th floor, the contractor opens a window. puts half his body out of the window. Way down, I can see the swimming pool. The people who are swimming there look like tiny ants down there. My leg is already shaking from the 37th floor, with this guy standing halfway down up to his waist. And he asked me to hold him, takes his handphone and takes photograph from outside, from inside. He writes a report saying that it's not possible, the damage is from inside. There's no way water can leak from inside unless the water could come in from the outside. So, and in order to seal off that crack, a gondola has to be brought from the 40th floor down, bypassing three floors to reach the 37th floor. And according to the Act, a common area is one where two or more parcel owners have access. So if you have to come down from the 37th floor, 40th floor to 37, three floors, you're bypassing three parcels. Obviously, that area is a common area. So what I did, I took the photographs, I took the report of the contractor, I referred to the regulations, what is a common area, sent it to the COBKL. The COBKL came and made a second inspection, and they directed the MC to repair it. They said this is a common area damage. The MC then repaired it. So this is the procedure that you will have to take in order to get this interfloor leakage or party wall damage done up. Thank you.
Okay, that's a good example. I hope it answer your question. So moving on to the next question, which is from Chan Eileen. Hi, Mr. Patrick. Is the manhole piping at the balcony a common property? If leakage occurs due to loosened cap and causes damage to the downstairs parcel unit, should such repair costs be borne by upstairs parcel owner or developer JMB or MC? Thanks.
Okay, to answer this question, we need to look at three things. I mean, basically, one thing, what is the cause of the damage? What's the cause of the leakage? Now, a lot of people, just because they have a balcony, they like to go and put plants down there. And then they water their plants every day. And these plants either have roots which start creeping here and there and finding its source there. And people, I mean, uh, I used to go to Sungai Buloh very often to buy flowers. I like roses, I like Christmas trees, you know, I like bougainvillea plants. So I buy them. And then sometimes my daughters come with me and they also like plants. They buy. For 2 weeks, they're very excited. After that, they forget about it. And then the plants dry up. This is something which is very common. So when you don't water the plants, their roots start going here and there. And definitely they look at the manhole there because there's moisture down there. And then when you over water the plants, soil tends to leak. And when the soil drains out, they also go and jam up the manhole. It has to be remembered that although the balcony belongs to you, it's part of your parcel, nevertheless, that manhole is generally common property because that manhole is access not only to your unit, it is also access to the unit above and to the unit below. However, if it is no different from an owner who renovates his house, that becomes a cause of damage to the floor below. So, it is the liability of the owner if the cause of damage to that conduit, that pipe, is as a result of putting plants down there, soil getting caught, and then the roots going in there. And roots are very powerful, they can cause big damage to all this. We must understand, gone are the days of using GI pipe, galvanized iron pipe, for all this kind of piping. Nowadays, we are using PVC pipes. And PVC pipes cannot stand against plant roots. If, however, the damage is because of the poor quality and poor workmanship of the developer, then developers should be at fault. So it is a duty of the management to go and inspect and see who is or what is the cause of this damage, and then they will accordingly decide who is to repair it. All right.
Okay, thank you, Mr. Patrick. So moving on to the next question, from Oi Sumi. Actually, there is another question. I think this is related, so I'll just read the question. What about the parcel owner is a defaulter for many years and requests MC to repair inlet water pipe leakage? How to deal with this defaulter? And the next one, or MC has responsible to repair any common parts of buildings, even the parcel unit is a defaulter.
All right. First of all, if a person is a defaulter, I would think that a responsible MC or JMB should file a suit in the tribunal to recover the money. Now, it is possible that the MC may not be able to repair many parts of a building, even common areas. For example, lifts. Very often, lifts are not repaired because the people do not pay their maintenance charges. I've shared before that I've gone down to this Pantai PPR, and we go along this Bangsa Road and Pantai PPR and see the people who are living there. I'm sure it's not happening now. When I went there, somewhere about 10, 12 years ago, we were visiting some poor people to provide provisions for them. And the lady told me, and my colleague was with me, that once I reached that area, not to come in, but to call her first. We were getting a little bit suspicious, but she said, please, she insisted. So once we parked way out, she said, don't park your car inside, park your car way out. So we parked our car way out. And then we walked, we called her, and she came and met us halfway, and she took us. She said, walk here, don't walk there. Reason, the lifts are not maintained because nobody pays their maintenance charges. The management group says, we have no money to repair the lifts. We've been calling these people, they have repaired the lifts, we owe them money, we can't pay them, they don't want to come. So what do people do? People throw rubbish out of their windows and balconies. And he said, people throw even heavy things like furniture out. And while I was there, something which I saw with my own two eyes, somebody was shouting from upstairs that they're going to throw things, ask people to move, and they threw a single door fridge from the seventh floor. Can you imagine a fridge being thrown down the seventh floor? And it made a big dent in the road down there. I saw this. I did not hear this. I saw this. And I was so frightened that I told my colleague, I'm never ever going to come to this place again. I cannot bear the thought of a fridge falling on my head, right from there. Now, what audacity or what ethical moral value can a person who is the defaulter claim that the management team must repair his unit at any cost? Right? He has no right to do that. Now he must see what is the cause of this water pipe leakage. Is it because of the developer? If it is the developer who has caused because of poor workmanship, poor design, you see, water, sometimes people like to join elbows, PVC pipes, they join a lot of elbows. The effect of joining too many elbows is when water comes at full force, elbows will crack because there's resistance there. As far as possible, pipes should be straight. So, this is a basic design concept. Now, if there are too many elbows and therefore the defect is in the design or the quality of the materials being used, the parcel owner should sue the developer. You can only sue the management team if you can show the defect is due to poor maintenance. And when you mention the word maintenance, then you have to pay your maintenance charges. Simple as that. There is no absolute duty on the part of the management to do it for you. Sometimes the management does it because I advise them, if you do not repair this water inlet or any other pipes or conduits, there's a possibility that the damage which results will not only affect the defaulters unit, it will affect other units, and those people may have been regular paying customers. In that case, they will bring an action against you as a management. And at that point of time, you cannot blame and say, look, that fellow didn't pay maintenance, so we did not maintain. Yeah, if he doesn't pay, you don't maintain. But now your failure to maintain is called damage to another innocent party. That is the danger. All right.
Okay, thank you, Mr. Patrick. Okay, so moving on to the next question from Fatiha Atira. How soon will the JMB or developer may carry out the inspection after the notice has been made? Thank you.
As per the regulation, they have to inspect not as soon as practicable. The regulations say as soon as practicable, depending on the urgency of the matter, not in any event not later than 7 days. So they have 7 days to do it, right? If it's an emergency bad, they can go in straight away, right? They can go in straight away. Okay.
Okay, so moving on, this is our last question
Mhm.
from TF Tan. Okay, hi Mr. Patrick. If let's say the property DLP are not available anymore, are we still allowed to ask the developer to fix the issue, example, wall crack and water leakage inside our master bedroom?
Okay. Now, to answer this question, we're going to look at several rules. First of all, your defect liability period is a contractual provision. And being a contractual provision, of course, once it is already beyond the defect liability period, the developer is not bound anymore. However, there are the types of defects that take place can be divided into two categories. One are defects which are easily visible. You can clearly see it. For example, you can see a leakage. If you see a leakage on your ceiling, right? If it's an interfloor leakage, I'm quite sure the interfloor leakage could not have a reason overnight. It may have come after quite some time. So, there are defects which only show much later. These defects are called latent defects. Late, from the word late, they are called latent defects. Now, first of all, it is your defect liability period is a statutory period. Full stop. But don't forget, the developer is also managing the place after giving vacant possession. He will manage the place. Now, if you go by the standard procedures, within 12 months of giving vacant possession, the developer is supposed to call for the first AGM of the JMB. So, developer manages. During these 12 months, from vacant possession until the first AGM of the JMB, the developer is still liable to maintain these. So you can still call upon the developer to do it, right? That's one. This is defect liability period only. Number two is the fact that apart from the defect liability period, there is what we call defective design, poor workmanship, poor materials being used. That is a different question from a defective liability period. So you can also bring an action against the developer for poor quality materials that are being used, if it can be proven subsequently that this is the cause of the damage or the water leaking, right? Thirdly, it could be poor maintenance by the developer during these 12 months from vacant possession until handing over to the JMB. So during this time, right, if it can be attributed to poor management of poor maintenance, right, you can still sue the developer. Of course, we must add on that some developers, they will on an ex gratia basis do a repair. Now, although this, I remember a principal of private college in Penang in the 1990s, she bought a Mercedes C200 from Low Motors. And after about 3 years, there's something wrong with the car, it could not start. She took it back to Low Motors and they told her the warranty has already expired. And then she will have to pay about $6,000 at that time. This is in 1997, 1999. She had to pay that amount of money to get it repaired. So she spoke to them and said, look, I buy a good car. You're supposed to give me a good car. These things don't happen. So she put in an appeal. And finally, they only charged her $300 for service and they changed the part free of charge. So you may get on similar basis developers who on an ex gratia basis to maintain their good name, they may carry out these repairs. You never know. It may happen, but that does not mean that they are contractually bound to do it. They may do it on an ex gratia basis. But otherwise, you have to go under your defect liability period. You have to go under poor workmanship, poor quality of materials used. You may have to go under poor maintenance within the 12 months before handing over to the JMB. If that is the kind of action you want to bring against the developer. Thank you. I hope that answers the question.
Okay, all right. So we have another 2 minutes before we end our session. I will just pick the last question for you from Oi Su Ming. Can Mr. Patrick guide us how to file a tribunal case against defaulter in next webinar?
Oh, you're talking about next webinar or next
Yeah,
talk show? Okay.
next.
All right. I don't know, talk show or next webinar. All right. We will definitely look into that. Uh, I did. I think I did a seminar before on resolving disputes. In that place, I discussed in detail how do you file the case in the tribunal. But we will definitely keep this in mind. We will try to do it and to guide you on how to do the to how to file the case in the tribunal. Yes, we will try.
Okay, great. Thank you so much, Mr. Patrick. I think that is all for tonight. And thank you everyone for joining our fourth episode of the Strata Talk Show by the Excel Academy. I hope Mr. Patrick answered all your questions and have a clear view on this topic. So before I end our session, I would like to invite everyone here to attend our seminar on the upcoming 11 and the 16 December 2021. For 11 December, the topic is about managing defects and disputes in strata properties by Mr. Patrick as well. And for the 16 December 2021, the topic is about pengurusan mesyuarat agung AGM and mesyuarat agung luar biasa EGM by SR Muhammad Rus Izhar. So if you like to join the said seminar, you can contact our number as stated below, which is 017-856-2228, and you can register with us. And with that, thank you everyone for joining us tonight. See you in our next session. Thank you and have a good night. Thank you, Mr.
Thank you.
Patrick.
Thank you very much. Thank you all for participating. Thank you for your questions. Good night to all of you.
All right, good night.